Live look now at the U.S. Capitol tonight, where the U.S. House sent the president a major bill that could change how we use the internet. The bill would take away the FCC's online privacy protections that were going to take effect at the end of the year. Lori Mazzucawa joins us now with details on the changes and how they could affect you.
Amanda and David, if it becomes law, the bill would allow internet service providers like Verizon, AT&T, and Comcast access to your data without your permission. And that includes search history, location, emails, messages, even health data. The providers would be able to monitor your customers' behavior online, use your personal information to sell ads, again, without your permission. They could even sell your information directly to marketers, financial firms, and others who can use that information again without your consent. And service providers would no longer be required to improve protection against hackers and thieves. Republican backers say their bill gets government out of the internet business. Democrats say it's just outrageous.
So the message to the American people is clear. Your privacy doesn't matter. And your web browsing history should be available to anyone who will pay the highest price for it.
These broadband privacy rules are unnecessary and are just another example of big government overreach.
The bill, if it becomes law, would also prohibit the FCC from restoring privacy rules in the future. Now, the Wall Street Journal has suggested a couple of ways to protect yourself from your service provider. First, use only HTTPS sites. That stands for Hyperlink Transfer Protocol Secure, and that provides a layer of security. Second, consider using a virtual private network, or VPN, which serves as a buffer between you and your internet service provider. David, Amanda?
Okay.
For what purpose does the gentleman from Texas seek recognition?
Mr. Speaker, by the direction of Committee on the Rules, I call up House Resolution 230 and ask for its immediate consideration.
The clerk will report the resolution.
House Calendar Number 28, House Resolution 230, resolved that upon adoption of this resolution, it shall be in order to consider in the House the joint resolution, Senate Joint Resolution 34, providing for congressional disapproval under Chapter 8 of Title 5 United States Code of the rules submitted by the Federal Communications Commission relating to protecting the privacy of customers of broadband and other telecommunication services. All points of order against consideration of the joint resolution are waived. The joint resolution shall be considered as read. All points of order against provisions in the joint resolution are waived. The previous question shall be considered as ordered on the joint resolution and on any amendment thereto to final passage without intervening motion except one. 1 hour of debate equally divided and controlled by the chair and ranking minority member of the Committee on Energy and Commerce. And 2, 1 motion to recommit.
The gentleman from Texas is recognized for 1 hour.
Mr. Speaker, for the purpose of debate only, I yield the customary 30 minutes to the gentleman from Colorado, Mr. Polis, pending which I yield myself such time as I may consume during
For as much time as he wishes to use.
During consideration of this resolution, all time yielded is for the purposes of debate only. Mr. Speaker, I ask unanimous consent that all members have 5 legislative days to revise and extend their remarks.
Without objection.
Mr. Speaker, House Resolution 230 provides for a rule to consider a Congressional Review Act resolution which will undo a duplicative regulation put into place by the previous administration in the final hours of that presidency. The rule brings before the House this resolution so that Congress may remove, through the proper legislative process, rules promulgated by bureaucrats who remain unaccountable to the American people. This process allows those who are accountable, the elected representatives in Congress, to fight for our constituents' rights and liberties. House Resolution 230 provides for a closed rule for the Congressional Review Act resolution SJ Res 34, the standard procedure for such resolutions, since the sole purpose of the resolution is to remove a regulation from the Federal Register. The rule allows for 1 hour of debate equally divided between the chair and ranking member of the Committee on Energy and Commerce. Further, the minority is afforded the customary motion to commit. In 2015, the Federal Communications Commission issued its Open Internet Order, reclassifying broadband providers as common carriers, which brought them under the jurisdiction of the Federal Communications Commission. The Federal Trade Commission is the primary regulator of companies' privacy and data security practices. However, the Federal Trade Commission's regulatory authority under Section 5 of the Federal Trade Commission Act does not extend to common carriers. Therefore, the reclassification of broadband internet service providers as common carriers created a legal enforcement gap. The Federal Communications Commission determined that the privacy provisions of the Communications Act would now apply to broadband internet service providers and that new and expanded privacy rules were necessary. Therefore, the Federal Communications Commission promulgated new privacy rules for common carriers on October 27th of 2016. These rules were adopted a mere 10 days before the 2016 presidential election. They were adopted on a party line vote and over serious objections by the minority commission members and the internet service providers. The Federal Communications Commission's rules are a departure from the privacy protections that have been applied by the Federal Trade Commission for years. The Federal Trade Commission employs an opt-out model that requires companies to provide consumers notice of the data that is collected and how it will be used. Consumers are then given the option to opt out of this data collection if they so choose. Instead of implementing well-established collection practices that are accepted industry-wide, the Federal Communications Commission chose to promulgate an opt-in model for its new internet service providers. This model prohibits broadband internet service providers from using, disclosing, providing access to customer proprietary information without the customer's affirmative opt-in consent. Such data includes browsing history, application usage, location data, among other types of information. While this may sound like a good thing to opt in reality, it unfairly skews the market in favor of providers that already have access to consumer information. For example, search engines, social media sites, and internet content providers like Netflix, Google, Facebook, Amazon, and Apple. These providers, known as edge providers, are free to collect consumer data that broadband internet service providers under the jurisdiction of the Federal Communications Commission are not. The ability to provide consumer data drives the digital advertising market. The Federal Communications Commission's privacy rule arbitrarily treats the internet service providers different from the rest of the internet, amounting to government intervention in the free market. The Federal Communications Commission stated that the rules would provide more transparency. The rules would provide more choice. The rules would provide more protection. However, these expanded provisions may also result in more frequent breach notifications, leading to a weaker focus on security by consumers who do suffer from notification fatigue. While the Federal Communications Commission's privacy rules were meant to protect consumers, they actually can inhibit security and market competition while creating confusion by subjecting parts of the internet ecosystem to different rules and different jurisdictions. To correct this policy, on March 23rd of 2017, the Senate passed S.J. Res. 34, a Congressional Review Act resolution of disapproval to nullify the privacy rulemaking promulgated by the Federal Communications Commission. Prior to the reclassification of broadband internet service providers as common carriers under the jurisdiction of the Federal Communications Commission, the Federal Trade Commission regulated companies' privacy practices while preserving the Federal Communications Commission's authority to enforce privacy obligations of broadband service providers on a case-by-case basis. This Congressional Review Act will restore the status quo that existed prior to the Federal Communications Commission's Open Internet Order and bring privacy practices of all parts of the Internet back into balance. Not only will this level the playing field for an increasingly anti-competitive market, but it will ensure parity in the protection of consumer data. The new chairman of the Federal Communications Commission, Ajit Pai, has called to halt the federal communications privacy rules. He stated, quoting here, "All actors in the online space should be subject to the same rules, and the federal government shouldn't favor one set of companies over another," close quote. This is precisely the type of limited government that we should be striving for after years of overreaching by the previous administration and its regulations. The Congressional Review Act protects consumers and it restores the free market competitiveness that actually allows our economy to thrive. The Congressional Review Act is an important tool. It's an important tool in maintaining the accountability at the federal level. Its necessity has never been more apparent than over the past 2 months, where this Congress has needed to step in and remove burdensome, unbalanced regulations put in place by the prior administration and their team just as they were walking out the door. House Republicans today will stand up for the rights of our constituents against the out-of-control federal bureaucracy. I urge my colleagues to support today's rule and the underlying Congressional Review Act resolution, and I'll reserve the balance of my time.
The gentleman from Texas reserves his time. Chair recognizes the gentleman from Colorado.
Mr. Speaker, up until now, every president since Gerald Ford has disclosed their tax return information, and these returns provide a basic level of transparency that helps ensure that the public's interest is placed first. The American people deserve the same level of disclosure from this administration. Mr. Speaker, if we defeat the previous question, I'll offer an amendment to the rule to bring up Representative Eshu's bill that would require presidents and major party nominees for the presidency to release their tax returns. Mr. Speaker, I ask unanimous consent to insert the text of my amendment in the record, along with extraneous material, immediately prior to the vote on the previous question.
Without objection, so ordered.
To discuss this proposal and also the important aspects of the underlying bill that need to be responded to, I'll yield 7 minutes to the distinguished gentlewoman from California, Ms. Eshu.
The gentlelady from California is recognized for 7 minutes.
Thank you, Mr. Speaker, and I thank my friend and colleague from Colorado for his leadership and for yielding time to me. First of all, I'd like to respond to the gentleman's presentation about the underlying bill. What the underlying bill does today, and make no mistake about it, is it wipes out. It totally wipes out privacy protections for consumers on the internet. That's what it does. There are not duplicative regulations. I know that it was stated on the floor that there are duplicative regulations. There are two agencies, the Federal Communications Commission and the Federal Trade Commission. However, it is only the FCC, the Federal Communications Commission, that can actually protect consumers by enforcing the protections. The FTC does not have that authority. And so what happens today if these privacy protections are ripped away from the American people? Well, all the information that you give to your internet service provider, whether it's Comcast, whether it's cable providers, Charter, AT&T, the one that you pay a pretty big bill to, they can take all of the information that they have, my account, your account, your account, your account, and use that information to sell it to the highest bidder, to make money off of it. Now, there's an additional charge in this thing, alleged charge, and that is, well, what about Google and Netflix and Facebook? What about them? Why aren't they subject to what the FCC did? Well, they are edge providers. They're edge providers. You don't have to go to Google. You don't have to go to Facebook. You don't have to go to Netflix in order to get your internet service. And so that's why the FCC did not apply these rules to them. And maybe there should be a debate about them. But to equalize and say that Google, Facebook are equal to your internet service provider suggests to me that some people just don't know what they're talking about. This is a This is a subject that the American people feel very, very deeply about. In fact, I think it's in the DNA of every American. I want my privacy, and it should be protected. We all feel that way. So what is being done today is a ripping away. It's like taking a bandage off, just stripping it away. And who do you go to? Who do you go to complain to? No one. No one, because there isn't anything left to enforce. So I think it's a sad day if the underlying bill passes. I think it's shocking that my Republican colleagues, either out of a lack of understanding of how the internet works, how their constituents, all of our constituents, benefit from these protections of our privacy. And our information is private. I don't want anyone to take my information and sell it to someone and make a ton of money off of it just because they can get their mitts on it. And that's why the privacy protections were adopted. May I ask how much time is remaining?
The gentlelady has 3 minutes remaining.
A minute.
All right.
The gentlelady has 4 minutes remaining.
So I'll close that one off and go into the other reason that I'm on the floor today, and I thank the gentleman again for yielding me the time. I rise in opposition to the rule and obviously the underlying resolution, and I urge my colleagues to defeat the previous question so that my bipartisan bill, the Presidential Tax Transparency Act, can be made in order for immediate floor debate and a vote. Mr. Speaker, my legislation would require the President and all future presidents and presidential nominees to publicly disclose their tax returns. It's a very simple bill. This is the third time this year that I've offered this bill as the previous question motion, and for the last several weeks, members, including Mr. Polis, Mr. Pascrell, Mr. Crowley, Ms. Lofgren, and myself, have offered privileged resolutions directing the House to request the President's tax returns. Nearly every day we give the majority the opportunity to demonstrate leadership on this issue, and nearly every day they continue to help the President hide his tax returns from the public. Now, every president of both parties since Gerald Ford have voluntarily made their tax returns public. The President has 564 financial positions in companies located in the United States and around the world, according to the Federal Election Commission, making him more than susceptible to conflicts of interest than any president in our history. Without disclosure of his tax returns, the American people are prevented from knowing where his income comes from, whether he's dealing with foreign powers, what he owes, and to whom, and how he may directly benefit from the policies he proposes. There are daily revelations about previously undisclosed meetings between the President's staff and Russian officials, as well as a steady flow of troubling information about the Trump Organization's ties to state-connected businesses and individuals in Turkey, Azerbaijan, China, and other countries. Last week, the New York Times reported that the Trump Organization is finalizing an agreement to build a hotel in partnership with a firm that has, quote, deep Turkish roots and business ties in Russia, Kazakhstan, and 24 other countries. Without the disclosure of the President's tax returns, there is no way for the American people to know the full extent of his foreign entanglements and possible conflicts of interest on this or other deals that his family business is engaged in. I think the House is failing, Mr. Speaker, to exercise our constitutional obligation to conduct effective oversight and operate as a check on the executive branch. We can change that today by taking up and passing this bipartisan bill, which will ensure that the President and all future presidents will be held to a baseline level of disclosure. That's why I urge my colleagues to defeat the previous question so we can hold an immediate vote on the Presidential Tax Transparency Act, and I yield back the balance of my time.
Gentlelady yields back her time. The gentleman from Colorado reserves his time, and the chair recognizes the gentleman from Texas, Mr. Burgess.
Thank you, Mr. Speaker. I'll yield myself a minute.
The gentleman's recognized for a minute.
Thank you, Mr. Speaker, and bringing us back to the business at hand, which is the rule allowing the vote on the Congressional Review Act later today. I want to quote now from the webpage of the Federal Trade Commission under the title of Protecting Consumer Privacy. Reading from their website, the Federal Trade Commission has been the chief federal agency on privacy policy and enforcement since the 1970s, when it began enforcing one of the first federal privacy laws, the Fair Credit Reporting Act. Since then, rapid changes in technology have raised new privacy challenges, but the Federal Trade Commission's overall approach has been consistent. The agency uses law enforcement, policy initiatives, and consumer and business education to protect consumers' personal information and ensure that they have the confidence to take advantage of the many benefits of an ever-changing marketplace. Close quote. This is from the ftc.gov website, and I will submit this for the record. And I think I'll just take a minute to thank the men and women at the Federal Trade Commission for all the work they have done over the years in protecting our privacy. I'll reserve my time. Without objection, the document is entered, and the gentleman reserves his time. Chair recognizes the gentleman from Colorado.
I yield myself such time as I may consume.
The gentleman is recognized.
Mr. Speaker, I rise in opposition to the rule and the resolution. This resolution undermines fundamental privacy for every Internet user. And you hear my colleague on the other side trying to conflate different things. When your broadband provider can sell your information, and there's no rule prohibiting them from doing so, effectively that includes all of your browsing history, data entered in forms, everything that you've done on the Internet. That has absolutely nothing to do with, in a relationship with a particular content provider or e-commerce company, you can enter information, obviously for the express purpose of them optimizing your experience or selling you a product. They are then the owners of that information, and you have choice in the marketplace. Whereas with our broadband providers, most of us don't have a choice. You either sign up for the local cable company or you don't. Before I discuss the many disastrous facets of this resolution, I also want to point out that this is yet another closed rule. There have been absolutely no open rules that allow Democrats and Republicans to bring forward amendments. No amendments are allowed under this rule here on the floor of the House of Representatives. And sadly, that's become the norm. The FCC recently took steps to reevaluate their rule, and Commissioner Pai even paused their implementation to examine the FCC doing their job. Now, why would Congress step in and use the CRA authority, a very cumbersome authority that also prohibits future implementation of similar rules? In many ways, it hamstrings the agency. What we are worried about is that if this bill were to become law, it would essentially be impossible for the FCC to act to protect the privacy of Americans who use broadband ever again. So it's not a matter of a nuance under this rule. If we go through the process of passing a CRA, the FCC wouldn't be able to pass any rule, or if they did, it would be under a legal cloud to protect the privacy of the American people. That's the danger, that CRAs are effectively permanent. The second aspect is that the FCC has already established a notice and comment period that allows for comment on the new rules. That's by going around that, we would avoid government transparency. So here's what's at stake. On October 27, 2016, after a 6-month rulemaking process that was open to public comment, received comments, the FCC adopted a common sense rule to protect our privacy. The rule that we're talking about undoing basically does 3 things, which are great. It requires broadband Internet access service providers to obtain opt-in consent before using or sharing sensitive information. Sounds obvious that we would want that. We wouldn't want information that doesn't have an opt-in consent to be sold or used. That includes things like web browsing history or data that's entered on forms. It would also require broadband providers to use reasonable measures to protect the cybersecurity of our data. Again, of course. And third, requires that broadband providers notify consumers in the event of a breach of information. Again, just like we have with credit card companies, we want some kind of affirmative information that's given to consumers that your information may be breached if there's a cybersecurity threat that might do that. This bill undoes all those things. It says you don't have to notify people if there's a breach. You don't need to have reasonable measures to protect cyber security. And most importantly, with regard to privacy, it would no longer require opt-in consent before using, sharing, selling your most intimate personal data that you use on the internet. Now, look at the implications of this rollback. It's not just a collection of internet usage and data, but bulk collection of all of your network traffic. A broadband provider could collect every search, every website visited, every email written and received, every piece of data entered, every article read, see how often you log in and how you use various accounts for all members of your family, including minors, and even your location. Sell that information and use that information without restriction and without opt-in. Think about what someone could conclude about this information. Your political affiliation, preferences, your health. What could they do with it? They could charge pricing of goods and services, discriminating against you based on your income or your past purchasing behavior. Your sensitive financial information could be used to steer you to higher cost and worse financial products. This rule would literally change how broadband providers have access to your entire personal life. It would make them, the broadband providers, the most valuable part of the internet value chain. Now, we all want broadband providers to have compensation for the infrastructure costs and a reasonable profit. There's no doubt about that. Those of us who advocate for net neutrality, as I do, those of us who advocate for privacy, we want them to have a reasonable return on investment so that we can all have access to broadband. And we have that largely through user fees, subscription fees. Have you seen your cable bill, Mr. Speaker? I've seen my cable bill. It ain't cheap anymore, but many families pay for it because it's the best way to have fast access to the internet. And guess what? The cable companies are able to justify broadband in many areas. Now, again, maybe there's some tweaks, and it would be great if there's a way we can have greater value for rural broadband and have them have an ROI. We would love that. But the answer is not to turn over the keys to the internet and all your personal data to cable companies and say you own it all. You're more powerful than Amazon, more powerful than Google, more powerful than every consumer site because you own everything that's entered into every one of those and more, and you can sell it and use it as you see fit without restriction, without even requiring that users opt in. The value conveyance from the content side to the infrastructure side of this bill would be game-changing and game-destroying for the free and open internet. It simply makes no sense. Look, consumers should have the right to choose who and how they share their personal information with. When it comes to a broadband provider, we simply don't have that choice that you do with consumer websites like Facebook or Google, which are governed under a separate set of laws. Proponents of this bill are arguing that because there's not adequate protection somehow in social media and the edge provider sphere, somehow the standards should be lower for broadband internet services. It makes no sense. In today's day and age, not having internet access is simply not an option for many Americans. To say you can choose not to have broadband, maybe in some places you can pay more for satellite and you might have some reasonably fast download but not upload and maybe spotty. Maybe you want to use dial-in over your phone. But for most of us, I use broadband. Most of us use broadband through our cable, because it's simply the most cost-effective way to have high-speed internet access, and that's the case for most American families. So this is not the time to get rid of privacy rules and convey the vast ecosystem that is the internet away from the content and dynamism that exists there to the broadband side. It's absurd. People can choose not to use social media accounts, can choose what they share, can choose who to enter contracts with regard to searches or purchases. Social media is an optional platform that you can choose between many providers, but the broadband access side frequently looks and acts more like a monopoly. Supporters of this bill also mention how this somehow levels the playing field for broadband providers. What it does is it tilts the playing field entirely in their favor. Internet service providers are a gateway to the internet, They do not own the internet. The second protection the rule offers is to require reasonable measures be taken to protect the data that they want to collect. And again, we all value cybersecurity and protection of this data. Given the countless incidents of cyber hacking incidents, how can we entertain the idea of rolling back a rule that requires reasonable measures to protect consumer data? What are proponents advocating for? No measures to protect consumer data? The third important protection under this rule is that consumers whose data has been breached should be notified. Again, that's important. I had my credit card stolen a few years ago and got notified that it was. I'd used it at another location where it might have been compromised. I received notification. This eliminates that notification from users of broadband. It would do away with that. I'd like to know, as would consumers, if my credit card information was hacked. I want to know if my personal profile or medical records or emails were hacked. If someone is able to obtain my children's names, our home address, the information about the schools they attend or the homework they do, I would want to know. Now look, this bill moves entirely the wrong direction. It basically seizes the value of the internet from content, from e-commerce, from all of the important dynamism that occurs there, and tries to apply that to the broadband side, rather than simply find a reasonable way for broadband providers to see a return on investment. I reserve the balance of my time.
The gentleman from Colorado reserves his time. Chair recognizes the gentleman from Texas.
I thank the Speaker. I'll yield myself 1 minute.
The gentleman is recognized for 1 minute.
Mr. Speaker, just to put some things in context, I wanted to share some information from a blog called redstate.com, posted by Seton Motley on March 27th of 2017, talking about the difference between the size and scope of edge providers versus the ISPs, the internet service providers. The parent company of one of the largest ed providers is valued at over $500 billion. He points out in his blog post, by way of comparison, the nation of Singapore's gross domestic product, the entire output for every man, woman, and child in a very productive country is $508 billion, basically the same. So the edge provider stands on equal footing, equal financial footing of the world's 40th richest country. By way of contrast, the nation's largest internet service provider has a net worth of $148 billion. So the edge provider is more than 3.5 times larger than the nation's largest ISP. I'll yield myself an additional 30 seconds.
The gentleman is recognized for 30 seconds.
I think we can begin to see the scope of the problem and why unbalancing this playing field is inherently a bad idea. I yield back. I've reserved the balance of my time.
The gentleman from Texas reserves his time. The gentleman from Colorado is recognized.
Well, yeah, the valuation is as it should be. I mean, again, when infrastructure is laid, we want a reasonable ROI. It's not like utility. It's like utility infrastructure, water infrastructure. I would never expect that the world's most valuable companies would be the pipes into people's homes. The magic of the internet is the content. That's the reason. That's what drives the desire for broadband access. And of course, there's other ways that people can access the internet, but broadband and cable have a technical advantage on price and speed. Mr. Speaker, I'd like to yield 3 minutes to the gentleman from Massachusetts, Mr. Capuano.
The gentleman from Massachusetts is recognized for 3 minutes.
Thank you, Mr. Speaker, and thanks, gentlemen, for yielding. I have a simple question. What the heck are you thinking? What is in your mind? Why would you want to give out any of your personal information to a faceless corporation for the sole purpose of them selling it? Give me one good reason why Comcast should know what my mother's medical problems are. You know how they'd know? Because when I went to the doctor with her and they told me what it was, I had no clue what they were talking about. I came home and I searched it on the net. And I searched the drugs that she was taking. The same with my children. Just last week, I bought underwear on the internet. Why should you know what size I take? Or the color? Or any of that information? These companies are not going broke. That's not the situation. The internet is not in jeopardy. This is plain and simple, and I don't get this. When I was growing up, I thought one of the tenets of the Republican Party that I admired the most was privacy. It's mine, not yours, not the government's, mine. You can't have it unless I give it to you. My phone number, my social security number, my credit card number, my passwords, everything is mine. And yet, you just want to give it away. You make one good argument. Let's level the playing field. And you're right. I agree with you. But you don't level the playing field by getting rid of the playing field. You level it by raising it on those who are not subject to this rule. Please give me one, not two, one good reason why all these people here, why all these people watching would want Comcast or Verizon to have information unless they give it to them. We're talking medical information. We're talking passwords. We're talking financial information. We're talking college applications. There is nothing in today's society that every one of us doesn't do every day on the internet, and yet Comcast is going to get it. Not because I said it's okay. And what are they going to do with it? Kind of look at it and say, oh yeah, hey, Mike takes a size 38 underwear. That's great. They're going to sell it to the underwear companies. Hey, he bought this kind of underwear. He likes this color. Let's give him ads. By the way, most of those ads are useless because I already bought the underwear. I don't need any more. But it's none of their information. It's none of their business. Go out in the street. Please leave Capitol Hill for 5 minutes. Go anywhere you want. Find 3 people on the street who think it's okay. And you can explain to them ROIs, and the company has to make progress, and we have to make money.
Gentleman's time has expired.
You'll lose that argument every single time, as you should.
Gentleman's time has expired.
And I guarantee you won't find anybody
Gentleman's time has expired. The gentleman from Colorado reserves. The gentleman from Texas is recognized.
Mr. Speaker, I'll reserve at this time.
Gentleman reserved. Gentleman from Colorado. Gentleman from Colorado. The House will be in order. House will be in order. The gentleman from Colorado is recognized.
Mr. Speaker, I'd like to yield 2 minutes to the gentleman from Minnesota, Mr. Ellison.
The gentleman from Minnesota is recognized for 2 minutes.
You know, Mr. Speaker, I do quite agree with what Mr. Capuano just shared, but I'll just say this. For anybody listening to this broadcast today, this is a classic fight of the big money against the many. The big money, they say that they want even more money, so they want to be able to dig into your private information so that they can figure out when you get up, when you go to bed, what you looked up, and then write ads just so they can try to sell you more stuff. And as disgusting as that is, you can see easily how that's not the end of it. What if there are people who are, what if you have somebody who has something really sensitive that they just want a little bit more information about, that it's not of a nature where it's saleable, but it's just their business? Well, somebody else is going to know now, and they may well be able to monetize it, gather it, and distribute it. It is outrageous what the majority is doing today, and I can't possibly believe that it is conservative, that it is small government. I can't believe that they believe that this is what a government in restraint should do. The government should be protecting our rights, protecting our privacy. Small government means that the individual ought to be protected from the big powers out there like the corporate interests, and yet the majority is handing us over to them at this very hour. I urge members of the majority to vote against this. I can't believe that a person who is a constitutional conservative would ever vote for a monstrosity like this. It is beyond my comprehension that a conservative libertarian would say, oh yeah, give the individuals information over to the big commercial interests. This is one of those moments. The majority, you guys have the House, you have the Senate, and you have the White House. The only restraint you have is yourselves. And I know there's got to be somebody in that body who believes that Comcast, Sprint, and all the rest should not have anybody's underwear size in this body. It is an outrage. It is an abuse. And I urge a very emphatic no.
Members are advised to direct their comments to the chair. Gentleman from Colorado reserves. Gentleman from Texas.
Mr. Speaker, I'll reserve it this time.
Continues to reserve. Gentleman from Colorado is recognized.
Mr. Speaker, I'd like to yield 1.5 minutes to the gentleman from California, Mr. Khanna.
The gentleman from Colorado, or California, excuse me, is recognized for 1.5 minutes.
Thank you, Mr. Polis, for yielding and for your leadership on this issue. This resolution would overturn rules that protect consumers' privacy. And they would be a handout to internet service providers, Comcast, Verizon, AT&T. Now, as it is, the average American, 80% of Americans don't have a choice about which internet service provider they can use. And they pay 6 to 7 times more than people pay in France, than people pay in Britain. And people wonder, why is this? Obviously, the United States did all the research that invented the internet. Why are Americans paying more? It's because they have monopolistic, anti-competitive practices. So what is the solution? Instead of making the industry more competitive so Americans have more choice and don't have to pay as more, what this bill wants to do is give these 4 or 5 internet service providers even more power, allowing them to take individuals' data and sell it to whoever they want. The fear of Big Brother is so real out there, as it is people fear that the bureaucracy and big companies are controlling their lives. This bill would allow that to continue and get worse. What we need is more anti-competitive legislation. What we need is a stronger Internet Bill of Rights that applies to ISPs and other Internet companies, not a rollback of the regulations that currently exist. I yield back my time.
Gentleman from California yields back. The gentleman from Colorado reserves. Gentleman from Texas.
Mr. Speaker, I'll reserve it this time.
And the gentleman from Colorado is recognized.
I'd like to inquire if the gentleman has any remaining speakers.
No, apparently not, Mr. Polis.
Well, I'll yield myself such time as I may consume. It's no surprise that nobody wants to come to the floor to talk in favor of this bill because it's such an awful bill. This bill would allow your broadband provider of internet services to sell all your personal information. So again, the other side is trying to conflate two entirely different things. When you do a transaction with an e-commerce site or a search site, you're agreeing to their terms of service and you're engaged in a discrete transaction, and the information that you enter is subject to their terms of use, completely appropriate. A competitor is only a click away. Whether there are any monopolistic content providers is a different matter for a different day and a different federal agency, the FTC. What we're talking about here is the access piece, the broadband access piece. They actually, through the pipes, get to see all the information that's entered that you see, every email, all your credit card information. If you use the internet for any personal medical research, all of your personal medical research, your kids' information, everything your kids and minors in the family do. And what this bill says is you don't have to require people to opt in to have their information used. Consumers should be in control of their own information. They shouldn't be forced to sell and give that information to who knows who simply for the price of admission for access to the internet. Again, we all want there to be a reasonable capital return on infrastructure and on broadband. That's something we can agree on. If there's a case to be made that we can do better in providing an economic return to encourage rural broadband, I'm for it. I know many of my colleagues on the other side would be for it. Let's do it. What we don't want to do in that process is turn over the entire value chain of the internet to the infrastructure and provider side rather than the dynamic, innovative content and e-commerce side. I'd like to read an excerpt from 2 letters from groups who are opposed to this bill. The first is a coalition of 19 media, justice, consumer protection, civil liberties, and privacy groups. They're concerned that, quote, without these rules, providers could use and disclose customer information at will. The result could be extensive harm caused by breaches of data or misuse. They remind us that, quote, the FCC's order simply restores people's control over their personal information and lets them choose the terms on which the ISPs can use it, share it, or sell it, end quote. Consumers should be in control of their own information. The second letter is from Consumers Union, the policy arm of Consumer Reports. They say, in part, that this bill would, quote, strip customers of their privacy rights and leave them with no protections at all, end quote. I'd like to submit those two letters to the record, Mr. Speaker.
Without objection.
And I also would like to submit a op-ed that I had the opportunity to publish last week to the record on this topic.
Without objection.
My piece is titled, Why Americans Should Be Worried About Their Online Broadband Privacy, talking about this very bill that Congress has the tenacity to try to bring to the floor under this rule to force the most personal pieces of information about every aspect of your internet behavior and that of your family members to be given to the broadband provider to do whatever they want with. Like these groups, I also believe that privacy is worth defending. In the wrong hands, information can be damaging and used for the wrong reasons. Simply put, this bill is about conveying the value of the internet to the infrastructure side rather than the content side. And rather than find common ground to establish reasonable ROI for broadband and internet investments, this bill would hurt the entire internet ecosystem by breaking down the trust between consumers and service providers. What they're really trying to do here is shift the reasonable burden for cybersecurity measures from the internet servers onto consumers. At the same time, they want to eliminate the requirements that cybersecurity measures even notify consumers of violations, and they want to collect more and more consumer data without any protections to do what they want with. Supporting this bill would make each and every user of the internet vulnerable to violations of our privacy and vulnerable to cybersecurity threats without even receiving notifications of when our own intimate information like credit card numbers is compromised. The FCC took a responsible, deliberate, and common sense step to establish broadband privacy protections in October 2016. If they need to be tweaked or changed, let's have a process to do that. This bill is not that process. It not only undoes those privacy protections, but prevents the FCC from ever issuing a rule that has those privacy protections in it. If passed, this bill would be an irrevocable step in the wrong direction. I urge my colleagues to vote no on this rule and the underlying bill, and I yield back the balance of my time.
The gentleman yields back. The gentleman's time has expired. The gentleman from Texas is recognized for the remainder of his time.
Thank you, Mr. Speaker, and I will yield myself the remainder of our time. Mr. Speaker, I will submit for the record an op-ed from the Wall Street Journal from March the 1st, 2017 by Jeff Flake, a member of the other body. The title of the op-ed is Settling a Bureaucratic Turf War in Online Privacy Rules. And I want to read or quote from a couple of lines from this op-ed. Senator states here, privacy is a cornerstone of consumer protection, with federal enforcement agencies striking an appropriate balance between innovation and security in their regulations. But just as a flawed line of code can render a new firewall program useless, new privacy rules that were rushed through in the waning days of the Obama administration risk crashing our longstanding privacy protections. Continuing to quote here, for 2 decades, the Federal Trade Commission has been America's sole online privacy regulator. Under the Federal Trade Commission's watch, our internet and data economy has been the envy of the world. The agency's evidence-based approach calibrates privacy and data security requirements to the sensitivity of information collected, used, or shared online, and applies protections in a consistent and even-handed way across different business sectors. Consumer behavior demonstrates the success of the Federal Trade Commission's regulatory approach. Each day, people spend more time engaging in online activities. Now, continuing to quote here, the Federal Communication Commission's overreach is a dangerous deviation from the successful regulation and common sense industry practices. But don't take my word for it. the Federal Trade Commission concluded that the Federal Communication Commission's decision to treat Internet service providers differently from the rest of the Internet ecosystem was, quoting here, not optimal, close quote, and that's agency speak for a really bad idea. One final quote from Senator Flake's op-ed: "This CRA resolution does nothing to change the privacy protections consumers currently enjoy." Let me just repeat that. This CRA resolution does nothing to change the privacy protections consumers currently enjoy. I hope Congress and the Federal Communications Commission will continue working together to address issues of concern down the road. However, it is imperative for rulemaking entities to stay in their jurisdictional lanes. We need to reject these harmful midnight privacy regulations that serve only to empower bureaucrats and to hurt consumers, close quote. And I will submit that for the record, Mr. Speaker.
Minute submitted.
Mr. Speaker, today's rule provides for the consideration of a critical Congressional Review Act resolution to repeal a duplicative federal regulation dropped on the doorstep of the American people in the last hours of the previous administration. The rule the House will be voting on today to repeal would create uncertainty and chaos surrounding the protection of people's privacy online. I want to thank Ms. Blackburn of Tennessee, the chairwoman of the Energy and Commerce Subcommittee on Communication and Technology, for her work on this critical issue. I urge my colleagues to vote yes on the rule and yes on the underlying resolution. With that, I yield back the balance of my time and move the previous question on the resolution.
The question is on ordering the previous question on the resolution. Those in favor say aye. Aye. Those opposed, no. Opinion of the chair, the ayes have it.
Mr. Speaker,
from Colorado.
On that I request the yeas and the nays.
The yeas and nays are requested. Those favoring a vote by the yeas and nays will rise. A sufficient number having risen, the yeas and nays are ordered. Pursuant to Clause 8 of Rule 20, further proceedings on this question are postponed. Pursuant to Clause 12A of Rule 1, the Chair declares the House in recess until approximately 3 p.m. today.
The House will be in order. The House will be in order. Members will please remove your conversation from the House floor. The House will be in order. For what purpose does the gentlewoman from Tennessee, Mrs. Blackburn, seek recognition?
Thank you, Mr. Speaker. Pursuant to House Resolution 230, I call up the joint resolution SJ Res 34 and ask for its immediate consideration in the House.
The clerk will report the title of the resolution.
Senate Joint Resolution 34, Joint Resolution providing for congressional disapproval under Chapter 8 of Title 5, United States Code, of the rules submitted by the Federal Communications Commission relating to protecting the privacy of customers of broadband and other telecommunications services.
Pursuant to House Resolution 230, the joint resolution is considered read. The joint resolution shall be debatable for 1 hour, equally divided and controlled by the chair and ranking minority member of the Committee on Energy and Commerce. The gentlewoman from Tennessee, Mrs. Blackburn, and the gentleman from Pennsylvania, Mr. Doyle, each will control 30 minutes. The House will be in order. The House will be in order. Members, please remove your conversation from the House floor. The House will be in order. The chair recognizes the gentlewoman from Tennessee, Mrs. Blackburn.
Thank you, Mr. Speaker. I ask unanimous consent that all members may have 5 legislative days to revise and extend their remarks and to include extraneous material on SJ Res 34.
Without objection.
Thank you, Mr. Speaker. I yield myself such time as I may consume.
The woman's recognized.
Thank you, Mr. Speaker. I do rise today in support of SJ Res 34, which disapproves of the rules submitted by the Federal Communications Commission relating to protecting the privacy of customers of broadband and other telecommunications services. I applaud Senator Flake's work on this issue, as SJ Res 34 was passed by the Senate last week. I also filed a companion resolution in the House. The FCC finalized its broadband privacy rules on October 27, 2016. At that time, they assured us that the rules would provide broadband customers meaningful choice, greater transparency, and stronger security protections for their personal information collected by Internet service providers. But the reality is much different. There are 3 specific problems with which the FCC has gone about these rules. First, the FCC unilaterally swiped jurisdiction from the Federal Trade Commission. The FTC has served as our nation's sole online privacy regulator for over 20 years. Second, having 2 privacy cops on the beat will create confusion within the Internet ecosystem and will end up harming consumers. Third, the FCC already has authority to enforce privacy obligations of broadband service providers on a case-by-case basis. These broadband privacy rules are unnecessary and are just another example of big government overreach. The Competitive Enterprise Institute estimates that federal regulations cost our economy $1.9 trillion in 2015. Since President Trump took office, Republicans have been working diligently to loosen the regulatory environment that is suffocating hardworking taxpayers. Here is what multiple House Democrats said in a letter to the FCC last May regarding the FCC's privacy rules. And I'm quoting from their letter now. The rulemaking intends to go well beyond the traditional framework that has guarded consumers from data practices of Internet service providers and ill-serves consumers who seek and expect consistency in how their personal data is protected. Further, FTC Commissioner Joshua Wright testified before Congress that the FTC has unique experience in enforcing broadband service providers' obligations to protect the privacy and security of consumer data. He added that the rules will actually do less to protect consumers by depriving the FTC of its long-standing jurisdiction in the area. Once again, these rules hurt consumers. Incredibly, former FCC Chairman Tom Wheeler referred to the Internet as the most powerful and pervasive network in the history of the planet before these rules were even created. I found this really odd because it implied that the FTC regulation had indeed been successful and ought to continue, ultimately undermining his own rationale for additional FCC privacy regulation. Now, there are a couple of myths that are going around that I want to take the time to dispel. Our friends claim there will be a gap for ISPs in the FCC privacy rules when they're overturned. This simply is false, and let me tell you why. The FCC already has the authority to enforce the privacy obligations of broadband service providers on a case-by-case basis. Pursuant to Section 201 of the Communications Act, they can police practices of the ISPs that are unjust or unreasonable. Sections 202 and 222 also protect consumers. It is already in statute. So I encourage my friends to read Title II of the Communications Act. Also, the state attorneys general have the ability to go after companies for unfair and deceptive practices. Third, litigation is another avenue consumers can pursue against the ISPs for mishandling personal data. Service providers have privacy policies. If they violate the policy, guess what? They can be sued. I know Democrats will certainly understand that, as they have many trial lawyer friends, and I urge them to speak to the trial bar. Fourth, the free market is another great equalizer. Can you imagine the embarrassment for an ISP that is caught unlawfully selling data? We've all seen the economic fallout from something such as a data breach. Companies have a financial incentive to handle your personal data properly, because to do otherwise would significantly impair their financial standing. To my Democrat friends across the aisle, the bottom line is this: the only gap that exists is in these arguments that you have made. Consumer privacy is something we all want to protect, and consumer privacy will continue to be protected and will actually be enhanced by removing the uncertainty and confusion these rules will create. As the Democrats Rush, Schrader, and Green indicated in a letter to the FCC last May. I also want to speak for just a moment on the edge providers, because there's been some question about who has visibility into your data. Clinton administration veteran privacy expert Peter Swire authored a report in February 2016 titled "Online Privacy and ISPs. ISPs' access to consumer data is limited and often less than access to others." Swire found that ISPs have less visibility into consumer behavior online than search, social media, advertising, and big tech companies. Swire's study found that as a result of advancing technologies, the rise of encryption, and the various ways and locations individuals access the internet, ISPs now have increasingly limited insight into our activities and information online. By contrast, however, so-called edge providers like search engines, social media, advertising, shopping, and other services online often have greater visibility into personal consumer data. Mr. Speaker, at this time, I reserve the balance of my time.
Gentlelady reserves. The gentleman from Pennsylvania is recognized.
Thank you, Mr. Speaker. I yield myself as much time as I shall consume.
Gentleman's recognized.
Thank you, Mr. Speaker. I rise today in strong opposition to Senate Joint Resolution 34. Today, colleagues, we are wading waist deep in the swamp. The American people did not ask for this resolution. In fact, no company will even put its name behind this effort. Instead, this resolution is a result of an explicit written request from Washington lobbyists. These lobbyists make the bogus claim that having actual protections will confuse consumers, and the only way to help clear up this information is to have no rules at all. No consumer has come forward to support this position. No consumer has said this argument even makes sense. I challenge every member of this body at your next town hall meeting to have a show of hands of how many people thinks it's a good idea to allow your internet service provider to sell their personal information without their permission. And then after you get that show of hands, ask them how many of them would vote for you if you support allowing corporations to do that. This resolution is of the swamp and for the swamp and no one else. The rules of this resolution would overturn rules that are simple and make common sense. They don't require much, only three things. One, internet service providers should ask permission before selling your private internet browsing history, app usage, or other sensitive information. Two, once they have your information, internet service providers should take reasonable measures to protect it. And finally, if the information gets stolen, the company should quickly let you know. That's it. That's all that's being asked of them. These modest rules don't stop internet service providers from using data for advertising and profiling or whatever else, so long as they ask first. ISPs have an obligation under these rules not to dive into the personal lives of Americans unless that's what those Americans want. They just need to ask first. This is particularly true because broadband providers see literally everything you do online, every website you visit, every app, every device, every time. By analyzing your internet usage and browsing history, these companies will know more about you than members of your own family, more than you tell your doctor, more than you know about yourself. And without these rules, these companies don't have to ask before selling all of that information, and they don't have to take reasonable measures to protect that information when they collect it. Make no mistake about this, colleagues. Anyone who votes for this bill is telling your constituents that they no longer have the freedom to decide how to control their own information. You have given that freedom away to big corporations. More importantly, there aren't rules to fall back on if Congress scraps these ones. Critics of the rules argue that the Federal Trade Commission should oversee the privacy protection for broadband providers. But under current law, they have no authority to do so, and the CRA won't do a thing to fix that. Under a federal court of appeals case, the FTC has no authority over mobile broadband providers at all. And to those that say the FCC can evaluate complaints on a case-by-case basis using its statutory authority, the current chairman, your current chairman, stated that Section 222 cannot be used to protect personal information and that rules are necessary to enforce this statute. Mr. Speaker, I want to ask unanimous consent to introduce that statement by the FCC Commissioner into the record.
Without objection.
Without these protections, there will be no clear rules of the road. And at a time when foreign actors like the Russians, the Chinese, and everyone else under the sun are constantly trying to steal our data and compromise our security, it would be irresponsible to roll back the only federal safeguards we have. I want my colleagues to think long and hard before you give corporations the ability to sell your information without their permission. Mr. Speaker, I ask for unanimous consent to introduce a number of items in the record. I have letters from a coalition of small ISPs, a coalition of civil rights organizations, and consumers union opposing this CRA. I also have articles by Free Press and the Open Technology Institute opposing the CRA, an op-ed from a current FTC commissioner opposing the CRA, and a memorandum from engineers at EFF opposing the CRA. And I reserve the balance of my time.
Without objection, the matters will be filed. And the gentleman is reminded to address the chair. Gentleman reserves. The gentlelady from Tennessee.
Thank you, Mr. Chairman. I will remind my colleagues across the aisle, Mr. Speaker, that again, Section 222 of the Communications Act covers the authority that the FCC needs. Traditionally, online privacy has been handled by the FTC. That is an authority that we have designated to them. At this time, I yield 5 minutes to the gentleman from Oregon who is chairman of the Energy and Commerce Committee, Mr. Walden.
The gentleman is recognized.
Thank you, Mr. Speaker, and I want to thank my colleagues for their good work on this legislation as we increasingly rely on technology in nearly every area of our lives. One of Congress's most important responsibilities is to strike the right balance between protecting consumers' privacy while also allowing for private sector innovation and the new jobs and economic growth that accompany it. The resolution before us today reverses overreaching, short-sighted, and misguided rules adopted by unelected bureaucrats at the Federal Communications Commission. These rules do little to enhance privacy, but clearly add a new layer of federal red tape on innovators and job creators. This is exactly the type of government overreach that the Congressional Review Act was meant to stop. The Federal Communications Commission, frankly, overstepped its bounds on many issues during the Obama administration, including privacy regulations. After stripping the Federal Trade Commission of its authority over the privacy practices of Internet service providers, ISPs, the FCC adopted short-sighted rules that only apply to one part of the Internet. Despite the FTC's proven case-by-case approach to privacy enforcement that frankly has protected consumers while simultaneously allowing ISPs to innovate, the FCC opted to abandon this model in favor of an approach that assumes the federal government knows best what consumers want. Simply put, the rules that the FCC applied to ISPs are illogical. The regulations would require companies to apply the same privacy protections to consumer data regardless of its importance or sensitivity. Hardly makes sense to treat a local weather update and personal financial information in the same way. In addition, the FCC's approach only protects consumer data as far as the Internet service provider is involved. An entirely separate set of rules applies to providers of edge services. That means that giant search corporations, one of which controls up to 65% of your searches on the Internet, they don't live by the same set of privacy rules as your small-town ISP. What America needs is one standard across the Internet ecosystem, and the Federal Trade Commission is the best place for that standard. The impact of these rigid regulations has the potential to stifle one of the most innovative sectors of our nation's economy. And it is consumers who will suffer. These rules, which Congress will repeal, only lead to higher costs, less competition, and fewer service offerings. This approach is particularly burdensome for small businesses, which do not have hallways full of lawyers to navigate these tedious and unnecessary rules. The benefits of the FCC's privacy regulations are questionable, but the harms are certain, which is why I urge my colleagues to support this resolution. And once these rules are reversed, the FCC can turn back to working together with the FTC to ensure that our privacy framework allows the Internet to flourish while truly protecting consumers. I yield back the balance of my time.
Mrs. Blackburn reserves her time. Gentleman from Pennsylvania.
Thank you, Mr. Speaker. I would remind my friends that under current law, the FTC has no authority to regulate ISPs, and that it was your commissioner, your current FCC commissioner, that said that they can't do it under Section 222 also, which I have submitted for the record. Mr. Speaker, I would now like to yield 4 minutes to the gentlewoman from California, Ms. Eshu.
Gentlelady is recognized.
Thank you, Mr. Speaker, and I thank my friend, Mr. Doyle, for both his leadership and for yielding time to me. America, listen up today. There may not be that many people on the floor of the House, but this is a big one. This is really a big one. Congress is poised today to betray the American people on one of the issues they care the most about, their privacy. Their privacy. Every single one of us cares about it, and so do the American people. I often say that every American has it in their DNA. Keep your mitts off of my privacy, what I consider to be private. Now, the consequences of passing this resolution are clear. Broadband providers like AT&T, Comcast, and others will be able to sell your personal information to the highest bidder without your permission, and no one will be able to protect you, not even the Federal Trade Commission that our friends on the other side of the aisle keep talking about. It's like open the door and there's no one there. That's what this thing creates. The Republicans are blowing a gaping hole in federal privacy protections by barring the FCC from ever adopting similar protections in the future. So if it's gone today, it's gone, period. The FCC rules are simple. They require broadband providers to get the permission of their customers, including all of us, before they can sell their web browsing history, their location information, and other sensitive data to third parties. The majority claims that we need to repeal these protections because they treat broadband providers differently than other online service providers, edge providers. Broadband providers are in the unique position of seeing everything we do on the internet. This is the reason, and it's reason enough to put privacy protections in place, but it's also important to keep in mind that consumers, all of us, pay a high monthly fee to broadband providers, and they face serious barriers if they want to switch. If I want to switch, if you want to switch, you have to many times pay early termination fees. This is completely different from other online services that collect consumer data. Consumers don't pay to use search engines or social media applications like Google and Facebook. If they don't like Google's privacy policy, they can switch over to Bing without paying any fees. But consumers can't do this with broadband providers, and therein lies the difference. Last week, we heard the Republicans bemoan the lack of choice in the healthcare market. They should take a closer look at the state of the broadband market, particularly in rural America, where only 13% of consumers have access to more than one high-speed broadband provider. So the majority is telling Americans today, particularly those in rural areas, that they need to choose between their privacy and their access to the internet. If this resolution passes, people across the country will certainly not have both. This resolution is, excuse the phrase, this is repeal without replace. The Republicans have not put forward any privacy proposal at all to replace the FCC's rules, despite knowing that repealing these rules will leave a gap in the federal protections. So the message to the American people is clear. Your privacy doesn't matter. And your web browsing history should be available to anyone who will pay the highest price for it. For all these reasons, I urge my colleagues to stand up for privacy rights and oppose this resolution. I yield back.
Mr. Doyle reserves his time. Gentlelady from Tennessee.
Thank you, Mr. Speaker. At this time, I yield all remaining time to Mr. Flores of Texas. He will control our time and manage that for our members. And I yield to Mr. Flores.
I thank the gentlelady for yielding the balance of her time to me. And Mr. Speaker, as an original co-sponsor of the House companion to S.J. Res. 34, I rise to strongly urge my colleagues to support the resolution before us today. Like all of my colleagues in the House, I care deeply about protecting the privacy of our constituents, but I cannot support the Federal Communications Commission's counterproductive rules that will actually harm consumers and stifle innovation. For 20 years, the Federal Trade Commission, or the FTC as we call it frequently, oversaw consumer privacy for the entire Internet ecosystem, content providers, advertisers, and Internet service providers, or ISPs. The FTC's privacy program focused on preserving sensitive consumer data and took the context of a consumer's relationship with businesses into consideration. The FTC's experience in implementing a wide range of rules and regulations has resulted in over 500 cases protecting consumer information, ensuring their privacy online. In a flawed political move, absent of any findings, complaints, or investigations to determine whether broadband providers had violated consumers' privacy or that the FTC had failed at doing its job, the FCC proceeded with a partisan vote to target ISPs and to expand its regulatory footprint. After stripping the FTC of its authority over the privacy practices of Internet service providers, the FCC subsequently adopted rules that would harm consumers and split the Internet, creating an uneven playing field between service providers and content providers. The Congress must fix this overreach so the new administration can create a comprehensive, consistent set of privacy protections. Consumers expect our privacy to be protected the same way, no matter what type of entity holds their data. Having two sets of requirements creates confusion for consumers and may jeopardize their confidence in the Internet. Our Internet economy has thrived under the privacy regime created by the FTC. Yet the FCC, under its previous chairman, Tom Wheeler, wanted to undermine that success by bifurcating privacy protections to serve outside political interest, not the American consumer. By contrast, the FCC's approach did not base its requirements on consumers' preferences about sensitive information and to set opt-in and opt-out defaults. Accordingly, its overall approach was top-down, heavy-handed regulation in stark contrast to the FTC's greater reliance on markets and consumer preferences. The FCC's rule has a number of problematic issues. The first is that the opt-in, opt-out regime reduces consumer choice and would be detrimental to the survival of many businesses in this country. The second is that the FCC would have prohibited unforeseeable future uses of collected data regardless of what consumers actually preferred and businesses may need. Third, the FCC would also have unjustly applied its heavy-handed approach to broadband providers, treating them more harshly than other players in the Internet ecosystem. In sum, the FCC's broadband privacy protection approach would have rejected free markets and ignored sound economics. Alternatively, the FTC private enforcement is market-oriented and flexible and adaptable to changes in consumer preferences and markets. It also creates companies and players neutrally, fostering an environment of competition and innovation. This resolution rescinds the FCC's rule, but it does not provide the FCC the opportunity to provide more, but it does provide, the FCC the opportunity to provide oversight more in line with the FTC, which has been successfully regulating online privacy for nearly 2 decades. This bill does not lessen or impede the privacy and data security standards that have already been established. We are simply restoring a more stable regulatory playing field to ensure that consistent, uniform privacy security standards are maintained to protect consumers and future innovation. Once Congress rejects these rules, the FCC can turn back to cooperating with the FTC to ensure that both consumer privacy across all aspects of the Internet is provided through vigorous enforcement and also that innovation is allowed to flourish. I urge my colleagues to support this resolution, and I reserve the balance of my time.
Mr. Flores reserves his time. Gentleman from Pennsylvania.
Thank you, Mr. Speaker. I would just remind my colleague once again that the FTC has no authority to regulate ISPs once this bill is implemented, and consumers will not be protected, and their current FCC commissioner has stated that. Mr. Speaker, I now want to yield a minute and a half to the gentlewoman from Colorado, Ms. DeGette.
Gentlelady is recognized.
Thank you so very much, Mr. Speaker. Mr. Speaker, I oppose this bill because it would remove consumers' right to control their online privacy and put it in the hands of corporations. Every time people go online, they create trails of data that has tremendous commercial value. This creates incentive for the ISPs to sell web history to a third party, be it an advocacy group, a for-profit company, or even a foreign government. Late last year, the FCC put Americans in charge of how ISPs use and share their consumer data. The FCC's rule also required that the ISPs engage in reasonable data security practices. Even if people believe that the FCC's rule went too far and should be modified, it's unclear how the FCC could move forward with such a plan given the constraints of the Congressional Review Act. Furthermore, as several people have mentioned, the FCC, which is charged with protecting consumers' privacy, does not even have the authority to oversee ISP practices. Given the number of data breaches in the recent years of companies such as Yahoo, we should frankly be strengthening data retention requirements, not weakening them. At its core, this bill weakens consumer protections today and makes them harder to implement in the future, which is why I oppose my colleagues to oppose it. I yield back.
Mr. Doyle reserves his time. Gentleman from Texas.
I am asking Mr. Johnson from Ohio 2 minutes to speak on this matter.
Gentleman's recognized.
Mr. Speaker, when the FCC reclassified the Internet as a common carrier, utility-style service, and adopted their rules regulating the use of consumer data by Internet service providers, it represented a monumental shift in the way we view privacy. Instead of a uniform technology-neutral standard that balanced data protection with consumer choice, Internet users were stuck with a two-sided approach that causes confusion and dampens competition. There is one set of rules for service providers and one set for the rest of the Internet ecosystem, but how often do consumers really recognize the difference between where their data is accessed and where it's stored? Ultimately, consumers are actually harmed by the artificial sense of protection created by these rules. It is essential that we take steps to restore the time-tested framework embraced by the Federal Trade Commission. We've talked a lot about protecting consumer privacy and data, but I haven't heard a lot about allowing the consumer to decide how their information is used. Consumers deserve to have the autonomy to control their information and their internet experience. As acting chairman of the FTC, Maureen Olhausen pointed out, the FTC approach reflects the fact that consumer privacy preferences differ greatly depending on the type of data and its use. There is widespread agreement that sensitive data, like financial or health information, should be strongly protected and opt-in appropriate. But what about other types of non-sensitive data? Let's not forget the ways that consumers benefit from allowing ISPs access to that kind of information. Consumers should retain the ability to make the decisions that make sense for them when it comes to how their non-sensitive data is used, and obtain the discounts or lower prices that can result. This vote isn't about reducing the level of privacy protection for consumers. It's about an FCC decision that ignored the preferences of consumers in favor of a regulatory power grab. I'm finishing up. Can I have 15 more seconds, Mr. Speaker?
We'll yield you 15 seconds.
The FCC's privacy rules are an overreaching regulatory mess that create confusion and inconsistency for consumers, harm competition, and upend internet privacy as we know it. And I yield back.
Mr. Flores reserves his time. Mr. Doyle.
May I inquire how much time remains on both sides?
Pennsylvania has 19 minutes. Gentleman from Pennsylvania has 19 minutes.
Thank you, Mr. Speaker.
From Texas has 11 3/4.
Thank you. And I would remind my colleagues that whether it's non-sensitive information or sensitive information, the ISP should ask for your permission to use it. At this time, Mr. Speaker, I want to yield 5 minutes to the ranking member of the Energy and Commerce Committee, Mr. Pallone from New Jersey.
Gentleman is recognized.
Thank you, Mr. Speaker. And I don't plan to use the entire 5 minutes, but nearly every day now we hear about new ways our enemies are trying to steal Americans' information. Just a couple of weeks ago, 2 Russian hackers were indicted for stealing personal information from millions of us. American consumers visit billions of internet destinations through a multitude of devices. Broadband providers potentially have access to every bit of data that flows from a consumer. And the American people are rightfully concerned about companies selling their personal information, including sensitive information like their location, financial and health information, social security numbers, and information about their children. So late last year, the FCC took steps to protect every American citizen's data and privacy, and the rules were simple. First, broadband providers had to ask their customers before selling any data. Second, the companies had to take reasonable measures to protect that data. And third, the companies had to let people know if their data was stolen. And that was a good first step, Mr. Speaker, but Congress also has a role in protecting our data, and we should be working in a bipartisan fashion to discuss ways we can better protect the American people's data. But instead, the Republicans have decided to spend this time wiping out the few privacy safeguards that we already have. The FCC cybersecurity rules are, in my opinion, not burdensome. They simply tell the network providers to be reasonable in protecting the data. That's all. The FCC left it to the companies themselves to use their best judgment on how to get the job done. They just needed to be reasonable. But it seems being reasonable is still too much for the Republicans. First in the Senate, now here in the House. So this resolution tells the companies charged with running the country's broadband networks that they no longer have to be reasonable when it comes to their customers' data. So I say, Mr. Speaker, make no mistake, this resolution is a gift to countries like Russia who want to take our citizens' personal information. And if the House passes this resolution, it will go straight to the president's desk, a president who will be more than happy to sign his name to this gift to the Russians. This resolution also gives large corporations free rein to take customers' data without anyone's permission. This debate is about whether Americans have the freedom to decide on our privacy. We hear all kinds of complicated arguments about jurisdiction, implementation dates, and who knows what else. But these arguments just muddy the water. Republicans will say that the FCC's rules are confusing to consumers. People won't know what to do if they're asked first before broadband companies sell their sensitive information. But if that were the case, we would have heard from people who oppose the rules, but we simply have not heard any of those concerns. The facts speak for themselves. Consumers want more privacy protection, not less. 74% of Americans say it's very important that they be in control of information, and 91% of people feel they have lost control over their own information. And there are real consequences to these feelings. Nearly half of Americans say they limit their online activity because they're worried about their privacy and security. So that's why they overwhelmingly support stronger protections. So the FCC listened to the American people, adopted reasonable rules, despite Republican claims to the contrary. The rules were not hard to follow. The rules still allow broadband companies to offer services based on their customers' data, and they can still customize ads or send reminders. The FCC's rules simply required companies to ask people first before selling their sensitive information. That's it. In fact, I had hoped the FCC would have gone even further, but the agency chose this more moderate approach. So as this debate proceeds, we should be asking one simple question. Should the American people have the freedom to choose how their information is used, or should the government give that freedom away? And I think the answer is clear. I stand with the American people, and therefore I strongly oppose this legislation. I yield back the balance of my time.
Gentleman yields back. Gentleman from Texas.
We yield the gentleman from Ohio, Mr. Latta, 3 minutes.
Gentleman's recognized.
Well, thank you, Mr. Speaker, and I thank the gentleman for yielding. Mr. Speaker, I rise today in support of the resolution and want to address an issue created by the Federal Communication Commission's misguided privacy rule in a recent Ninth Circuit case. For decades, the Federal Trade Commission has been the privacy cop on the beat for most industries, including the technology sector, protecting consumers from unfair or deceptive acts or practices. The Federal Trade Commission has brought over 500 privacy and data security cases to protect consumers. These include cases against internet service providers and some of the largest edge providers. The Federal Communications Commission is a regulatory body focused on regulating interstate and international communications by radio, television, wire, satellite, and cable. The Federal Trade Commission's work in privacy and data security has long been held up as a model by both parties, praising the agency for strong enforcement without overly burdensome regulations. During negotiations with the European Union to finalize the U.S.-European Privacy Shield, the Obama administration held up the Federal Trade Commission as the premier privacy enforcement agency. Unfortunately, in a midnight action, the Federal Communications Commission jammed through its own privacy rule that is very different from the framework that the Federal Trade Commission has been enforcing for decades. While we can reverse the poorly constructed FCC rule today, we must still address a recent court ruling. The Ninth Circuit recently ruled that the common carrier exemption in the Federal Trade Commission Act exempts an entity in its entirety from the Federal Trade Commission's jurisdiction if it engages in any common carrier activities, even if the company also engages in non-common carrier activity. I have introduced legislation to address the court's ruling with the gentleman from Texas, Mr. Olson. It is my hope that our colleagues would join us. This bill makes clear that the Federal Trade Commission has authority over common carriers when they are acting outside the scope of the common carrier. The repeal of the Federal Communications Commission's misguided privacy rule in the Ninth Circuit's opinion creates a gap in an irrational approach to privacy for consumers and will leave portions of the Internet ecosystem completely outside the Federal Trade Commission's jurisdiction. This bill makes clear that the common carrier exemption is important to ensure that no duplication regulation occurs, but at the same time, there are no loopholes left for certain companies to be outside the jurisdiction of the Federal Trade Commission. We need to be consistent in our approach to privacy and focus on consumer-oriented enforcement. This approach has been the foundation not just for Silicon Valley, but innovators across the country, and the bill sets right the decades of innovation that has spurred job growth in the United States and greater online services for consumers. I thank the gentleman for yielding, and Mr. Speaker, as I said, I yield back.
Mr. Flores reserves his time. Gentleman from Pennsylvania.
Thank you, Mr. Speaker. I'd remind my friend, since he acknowledges the court decision does not allow FTC jurisdiction and that he wants to introduce a bill, perhaps the Republicans should have done that first before scrapping the rules that leave ISPs with no rules. I'd now like to yield 2 minutes to the gentlelady from California, Ms. Matsui.
Gentlelady is recognized.
Thank you. Mr. Speaker, I rise in strong opposition to S.J. Res. 34. This is just the latest attempt from our Republican colleagues to use the Congressional Review Act to gut critical protections from American consumers. The Internet is increasingly intertwined with our daily lives, and nearly every American family uses the Internet to access and share personal and sensitive information. The business we conduct online includes financial information, details about our medical history, and even information on our kids. If this resolution of disapproval passes today, there will be no rules on the books to stop Internet service providers from selling that browsing history without your permission. And because our Republican colleagues are using the Congressional Review Act to overturn these critical consumer protections, the FCC can't go back and write new rules in the future. And despite what my colleagues on the other side of the aisle have said, the Federal Trade Commission cannot bring cases against broadband providers. That's why the FTC supported these rules when the FCC adopted them last year. Even if you think the FCC did not get these rules right, this resolution effectively eliminates the FCC from ever acting to protect consumer privacy in the future. We should be working together to address any real shortcomings if these rules need to be fixed. That's not what the resolution before us will do. I urge my colleagues to vote against this damaging resolution. Thank you, Mr. Speaker, and I yield back.
Mr. Doyle reserves. Mr. Flores.
Yield the gentleman from New Jersey, Mr. Lance, 2 minutes.
Gentleman's recognized.
Thank you, Mr. Speaker. I rise to support S.J. Resolution 34, which seeks to halt agency overreach by the Federal Communications Commission concerning the way broadband Internet service providers handle their customers' personal information. The FCC's broadband privacy rule, a midnight regulation adopted by executive order in the waning days of the Obama administration, unnecessarily targets Internet service providers and does very little to protect consumer privacy. The rule adds costly and unnecessary innovation-stifling regulations to the Internet and is another example of the federal government's picking winners and losers. When passed, the FCC claimed that the rule would provide broadband customers meaningful choice, greater transparency, and strong security protections for their personal information collected by Internet service providers. In reality, the FCC's rules arbitrarily treat ISPs differently from the rest of the Internet, creating a false sense of privacy. Consumer data privacy is of significant concern to every American, and the proper parties should address the issue. In this area, the Federal Trade Commission has historically held authority on the establishment and enforcement of general online privacy rules. Repealing the FCC's privacy action is a critical step toward restoring a single, uniform set of privacy rules for the Internet. This legislation puts all segments of the Internet on equal footing and provides American consumers with a consistent set of privacy rules to permit the FCC and the FTC to continue to work to ensure consumer privacy through enforcement. The FTC, the premier agency in this regard, has the experience to protect the privacy of the American people regarding the Internet, at least 20 years of experience. Bifurcation between the FTC and the FCC is not productive. A good question to ask the FCC: why did it wait to the last minute of the Obama administration to promulgate its regulation? Mr. Speaker, I believe it's important that we pass this SJR, and I rise to ask all of my colleagues to support it. I yield back the balance of my time.
Mr. Flores reserves. Mr. Doyle.
Yes, Mr. Speaker, I've heard about this last-minute dropping and late at night. Just for the other side's information, after a 7-month rulemaking process, this rule was adopted midday on October 26th. So let's get the record straight. Mr. Speaker, I'd now like to yield 3 minutes to the gentleman from California, Mr. McNerney.
Gentleman is recognized.
Well, first I want to thank Mr. Doyle for his opposition to this SJ Res 34. Mr. Speaker, and I rise in opposition as well. The FCC's broadcast or broadband privacy rules are common sense rules. These rules give consumers the ability to choose how their information is used and shared by their internet service providers. According to the Pew Research Center, a large majority of Americans say it's very important that they control who has access to their information. But despite a loud cry from the American people that they want to be able to choose how their information is used, SJ Res 34 strips consumers of the powers to choose how their ISPs use and share their information. This resolution also leaves consumers more vulnerable to attacks because their ISP will no longer be required to make reasonable steps to secure their personal information. In recent years, we've seen numerous data breach incidents that have jeopardized consumers' personal information. Some examples: Yahoo, Target, Home Depot, LinkedIn, and Anthem. The list goes on. And given the growing cyber threats that our nation faces, it's critical that we do more, not less, to secure consumers' data. Strong data security practices are critical for protecting our consumers' confidentiality. This resolution would make consumers' data more susceptible to being stolen and used for identity theft and other harmful, unauthorized purposes. Consumers want to be heard. They want more privacy. They want their information to be secure. We have an obligation to respond to their requests. And I'm appalled that one of the Republicans' first act in this Congress, after trying to take health coverage away from 24 million people, is to attack consumer protections and weaken data security. Americans are just now hearing about this legislation, and my phones are ringing off the hook in opposition. I have to rhetorically ask the other side, why are you pushing this? Americans don't want it, and your voters are beginning to pay attention. This is just after your humiliating defeat with the ACA repeal. I ask that you withdraw this bill and start listening to your constituents. I urge my colleagues to reject SJ Res 34, and I yield back.
Mr. Doyle reserves his time. Gentleman from Texas, Mr. Flores.
Thank you, Mr. Speaker. We yield 2 minutes to the gentleman from Louisiana, the GOP whip of the House, Mr. Scalise.
The gentleman's recognized.
Thank you, Mr. Speaker, and thank the gentleman from Texas for bringing forward this legislation. The FTC's light touch and case-by-case enforcement had fostered an internet economy that's become the envy of the world, much to the benefit of all American families and consumers across this country. But rather than following the FTC's proven framework of privacy protection, the FCC came in and overreached and missed the mark with these rules, injecting more regulation into the internet ecosystem. With all due respect, the internet was not broken and did not need the federal government to come in and try to fix it. The bottom line is that families expect and deserve to be protected online with a set of robust and uniform privacy protections. These rules simply do not live up to that standard. Rather than regulating based on the sensitivity of our data, these rules are applied unevenly based on what type of company you are or what kind of technology you use. Consumers should feel assured online that there's a cop on the beat with a track record of success, not an agency with a history of regulatory overreach. These midnight rules are harmful, inconsistent, and should be repealed, and I urge my colleagues to adopt this important resolution, and I yield back the balance of my time.
Mr. Flores reserves. Mr. Doyle.
Mr. Speaker, could I inquire how much time is left on both sides?
Gentleman from Pennsylvania has 10 3/4 minutes. From Texas has 5.
Thank you, Mr. Speaker. I will remind the gentleman these heavy-handed regulations that he speaks of are simply ask permission, protect people's data, and tell them if it gets stolen. That doesn't sound too heavy-handed to me. Mr. Speaker, I would now like to yield 2 minutes to the gentleman from New York, Mr. Tonko.
Gentleman is recognized.
And I thank you. I rise today in opposition to SJ Resolution 34, a bill that would strike most of the Internet privacy guarantees protecting the American people today. I have grave concerns with this effort. Our agenda here should be working on behalf of our constituents to protect their privacy and give them, not their service providers, data security. Instead, this effort would eviscerate any real online privacy protections and would limit data security. Some of my colleagues have claimed that this common sense rule has created challenges for consumers. I have found just the opposite. My office has been inundated with calls demanding that Congress protect their privacy and data security by opposing SJ Resolution 34. To everyone who has called, I hear you, and I stand with you in opposing this harmful and misguided effort. Back at home in New York's capital region, I have been hearing from many people who are frightened by the thought that this bill will become law and the last shred of their online privacy will be lost forever. They know how much information their internet service provider has mined from their search and browsing history, including financial, medical, and other very personal and sensitive details. And they rightly believe that they should have a say in when that information can be bought and when it can be sold. They understand that gutting these privacy protections would mean that internet service providers could sell their private information without their permission. It means their private internet browsing and search history, the text of their emails, and their mobile app usage can all be sold without their permission. They have a right to control who has access to where they are, what they search for, their financial information, their health information, and information about their children. They have a right to protect their Social Security numbers and the content of their emails. These rights are enshrined in our Constitution. Privacy rules also require providers to use reasonable measures to protect consumers' personal information, a clear and common sense standard that all who do business online should be required to uphold. And finally, internet service providers must notify customers if hackers breach the system, breach the system and may have accessed their private data. With hackers from Russia and elsewhere running rampant across the net, this is a critical provision for our American families. This is not too much to ask. The American people deserve to know that their data will be protected and that they will be notified if their data is compromised.
Gentleman's time has expired.
With that, I yield back.
Mr. Doyle reserves. Mr. Flores.
Mr. Speaker, I yield the gentleman from Texas, Mr. Olson, 90 seconds.
Gentleman's recognized.
Thank you, Mr. Speaker, and thank you, my friend from Texas. I rise today in support of SJ Res 34, which will protect consumers and the future of Internet innovation. The Internet is changing the way we communicate, shop, learn, and entertain. It's changing how we control our homes, our cars, and many other parts of our lives, including my 2 teenage kids. These changes give us certain expectations about privacy on the Internet. Until last year, the Federal Trade Commission provided a robust, consistent privacy framework for all companies in the Internet services market. Their holistic and consistent approach struck the right balance. Consumers' use of Internet services continues to increase, and their privacy has been protected. This resolution we're voting on today puts all segments of the Internet on equal footing. It provides consumers with a consistent set of privacy rules. I urge my colleagues to vote for innovation and consumers and vote for this resolution. I yield back.
Mr. Flores reserves his time. Mr. Doyle.
Mr. Speaker, I would remind my friends once again that this does not put us on equal footing. The FTC has no power to regulate ISPs under current law. With that, Mr. Speaker, I would like to yield 3 minutes to the gentleman from Massachusetts, Mr. Capuano.
Gentleman's recognized.
Thank you, Mr. Speaker, and I thank my friend for yielding. Mr. Speaker, we all know that our cell phones are tracking every move we make and keeping a record of it. Many people don't know, but your automobile is also doing the same thing. They keep a record of where you go. They keep a record of whether you wore your seatbelt. They keep a record of whether you applied the brakes or turned the turn signal on. Okay, that's your automobile. You don't have to drive. But just recently, in the last couple of months, we've learned that our televisions and children's dolls are doing the same thing. Last month, it was revealed that Vizio had spied on 11 million consumers by listening to them while their TV was off, because they can do it. Also last month, a child's doll called My Friend Kayla, for little girls or boys, was banned in Germany. Banned in Germany because that doll listens and responds, and it goes into the internet, and the doll's owner keeps and sells that information. This month, the teddy bear manufactured by a company called Cloud Pets was exposed for collecting more than 2 million voice recordings of children talking to their teddy bear. Now, maybe we accept that. I know that those are not the items that this bill would address. But the problem is you're taking an item for ISPs and reducing it down to this level. You say that your privacy is protected. I just gave you 3 examples in the last 2 months where your privacy is not protected. Neither is your children, neither is your family. In 2012, a giant international company, international ISP company, by the way, filed for a U.S. patent for a cable box that would sit in your house. It would watch you, it would record you, it contained an infrared sensor, and even take your body temperature with a thermographic, and that's a quote, thermographic camera. It would do all this without telling you, and would work whether the cable box was on or off. If you don't believe me, if you still have the courage to go on the internet, go find patent application number, now write this one down, 2012-03-04-206. That's the patent application number. It's still online. I want to read you one small segment from that 25-page patent application, and this is a direct quote. I'm not making up a single word. The device, quote, may detect that 2 users are cuddling on a couch during the presentation of a television program and prior to an advertisement break. Based on that detected action, the device would select a commercial associated with cuddling. For example, they have 30 seconds for
The gentleman an additional 30 seconds.
The device would select a commercial associated with cuddling. For example, a commercial for a romantic getaway vacation, a commercial for a contraceptive, a commercial for flowers, etc. Close quote. I didn't make up a single word of what I just read, and every one of you is sitting there with your mouth open that this might happen in your world. That's what this bill will allow. And you can't turn it off. You can't say, don't watch my children, don't watch my wife. This is a terrible bill. As I asked earlier today, what are you thinking? With that, I yield back, Mr. Doyle.
Mr. Doyle reserves his time. Mr. Flores.
Mr. Speaker, we are thinking that the gentleman's comments do not pertain to this bill, that this bill in no way is going to allow any of the activities that were described, whether it's cuddling or anything that's going to get in the way of any of that or allowed to be sold. So I yield the gentleman from New York, Mr. Collins, 2 minutes.
Gentleman's
Thank you, Mr. Chairman.
recognized.
I'd like to thank the people who worked to make this legislation a reality. As we become increasingly concerned with cyber threats, online privacy is a critical concern for every American. Unfortunately, in October of last year, the FCC issued regulations titled Protecting the Privacy of Customers of Broadband and Other Telecommunication Services, also known as Broadband Privacy Rules. These titles do not actually accurately reflect the impact these regulations are having on constituents' electronic privacy. These broadband privacy rules took Internet service providers, ISPs, which you subscribe to for TV and Internet access, and edge providers that deliver online applications, services, and website content, and separated them into 2 different groups. This has caused confusion among businesses trying to adhere to this change. While writing this regulation, the FCC had the opportunity to employ FTC precedent in drafting the broadband privacy rules, but instead chose to ignore existing precedent and create additional and onerous regulations.
The FCC believed that these new rules would give consumers more choice and heighten transparency. However, this has not been the case. This legislation does not remove privacy protections for consumers, and it does not expose consumer information. Both the FCC and the FTC will retain authority over consumer privacy on a case-by-case basis. ISPs will continue to be subject to the Communications Act of 1934, which protects all consumer proprietary network information. This is in addition to the many other existing federal and state privacy rules that ISPs must continue to follow. This proposed system separating edge providers from ISPs creates confusion for both consumers and business operations. This legislation works to reduce the confusion that has been created from this unnecessary regulation that has stifled competition and impeded innovations. I'm happy to support this legislation, which will provide much-needed clarity to the ongoing debate, and I yield back.
Gentleman from Texas reserves his time. Mr. Doyle.
Mr. Speaker, could I inquire how much time remains?
Gentleman has 5 1/4 minutes.
Thank you, Mr. Speaker.
From Texas, 2 minutes.
I just remind my friends you can say it as many times as you want, but the fact of the matter is that under current law, the FTC has no authority to regulate the FCC, and the FCC commissioner has said that you cannot do this without a rule in Section 222. I would now like to yield the magic minute to our House Democratic leader, Ms. Pelosi.
Gentlelady is recognized.
Speaker, I thank the gentleman for yielding, and I thank him on behalf of my 5 children and my 9 grandchildren and everyone I know, as a matter of fact, for being a champion for privacy for the American people. Thank you, Mr. Doyle, for your leadership. Thank you, Mr. Pallone, for yours, and Congresswoman Eshoo has been a champion on this issue as well. Can we move this? Okay. Thank you. Mr. Speaker, Americans turn to the internet for so many things these days: buying books, filing taxes, learning about why they are feeling sick. The website, the Republicans want this information to be sold without your permission. The websites you visit, the apps you use, your search history, the content of your emails, your health and financial data. Overwhelmingly, the American people do not agree with the Republicans that this information should be sold, and it certainly should not be sold without your permission. Your broadband provider knows deeply, our broadband providers know deeply personal information about us and our families. Where we are, what we want, what we're looking for, what information we want to know, every site we visit, and more. They can even track us. Our broadband providers can even track us when we're surfing in a private browsing mode. Americans' private browser history should not be up for sale. Yet Republicans are bringing SJ Resolution 34 to the floor to allow internet service providers, excuse me, Mr. Speaker, I had to get this, to profit. This is about profit from America's most intimate personal information without our knowledge or our consent. Republicans' use of the Congressional Review Act will do permanent damage to the FCC's ability to keep America's personal information safe. As the FCC Commissioner Clyburn and FTC Commissioner McSweeney warned, this legislation will frustrate the FCC, the Federal Communications Commission's future efforts to protect the privacy of voice and broadband customers. It's important for our constituents to know that if the Republicans had a problem with this particular policy, they might tweak it and say, we don't like it this way or that, in regular legislation, so that we could have a debate on it. It could go back to the Federal Communications Commission. They could revise it and send it back if it were a legitimate presentation of concerns. But it's not about a legitimate presentation of concerns. It's about increasing profits at the expense of the privacy of the American people. So, as I say, the Republicans' use of the Congressional Review Act does permanent damage and also damages the FCC's ability to keep America's personal information safe. With this measure, Republicans would destroy Americans' right to privacy on the internet. We made that clear, and forbid any effort to keep your personal information safe. Republicans are bending over backwards. Think of it. Think of the context of all of this. Since Gerald Ford was president, every candidate for president, every nominee of the major party, every candidate for president of the United States, Democratic and Republican, has released their income tax returns out of respect for the American people. Out of respect for the American people. Week in and week out, in fact, sometimes day in and day out in committee as well as on the floor, the Republicans have kept their president's income tax returns private, when the public has a right to know that the public has always known that about every president since Gerald Ford, in fact, since Richard Nixon, although in his case it wasn't voluntary. So while they're hiding President Trump's tax returns, some discrete piece of information that the public has a right to know, they are selling your most personal and sensitive information, again, your browsing history, your children's location, everything, to anyone with the money to buy it. Incognito tabs or private browsing modes will not protect you from the internet service providers watching and selling. As Mr. Capuano pointed out, watching and selling. Republicans have picked the week after Russian spies were caught hacking into 500 million American email accounts to open the floodgates, overturning the requirement that internet service providers keep their sensitive data secured from cyber criminals. The American people deserve to be able to insist that intimate details and information about their browser history be kept private and secure. So how's this? We have this magnificent technology that science has made available to people to facilitate commerce, to learn about different subjects, to privately pursue in a way that they may not even want their families to know what symptoms they have and what illness that might tell them about. Most Americans have no or limited choices for broadband providers and no recourse against these invasions of their privacy. Because with this measure, Republicans turn their back on the overwhelming number of Americans who want more control over their internet privacy. Americans can choose who represent them in Congress. Americans are paying close attention. They want to know who is taking a stand with them in opposing efforts to sell their private information to the American people. This is staggering. This is almost a surrender. If the Republicans are allowed to do this, we have surrendered all thoughts of privacy for the American people. Privacy is a value that the American people treasure. It's about their dignity. It's about their dignity. We cannot allow the Republicans to sell the dignity of the American people. I hope that everyone will vote no on this most unfortunate assault on the dignity of the American people. And yield back with balance.
Gentleman from Pennsylvania reserves his time. Mr. Flores.
We reserve.
Gentleman reserves. Mr. Doyle.
Thank you, Mr. Speaker. At this time, I'd like to yield 1 minute to the gentlelady from Illinois, Ms. Shankowski.
Gentlelady is recognized.
I thank the gentleman for yielding to me. Last week, Republicans tried to take away your health care, and today they're trying to take away your privacy. Republicans have said broadband providers and other internet companies should be under the same privacy rules. But oddly enough, when the committee considered an amendment to give the FTC, the Federal Trade Commission, rulemaking authority, like the FCC, a change that would allow the agencies to adopt the same privacy protections, every single Republican voted no. In fact, Republicans proposed making it harder for the FTC to pursue privacy and data security cases. The protections that the FCC adopted last year were very simple. Consumers should know what data is being collected, opt in to sharing of sensitive data, have their data reasonably protected, and receive notice when their data is compromised. But this dangerous resolution puts America's privacy and data security at risk. I urge all of my colleagues to stand up for consumers and vote no. I yield back.
Mr. Doyle reserves his time. Mr. Flores. Mr. Flores reserves.
Mr. Speaker, at this time, I'd like to yield 1 minute to the gentleman from Rhode Island, Mr. Langevin.
Gentleman is recognized.
Thank the gentleman for yielding. Mr. Speaker, I rise in strong opposition to this resolution of disapproval, which would repeal broadband privacy rules by being implemented by the FCC. As co-chair of the Congressional Cybersecurity Caucus, I hope I can offer some additional perspective on this debate. Studying the many threats our country faces in cyberspace, I have become deeply aware of how ingrained the Internet is in every aspect of our lives and our economy. And that has also helped me understand the unique role of broadband service providers to grant access to the great potential of the information age. By necessity, ISPs can see every bit of traffic that leaves your network for the broader Internet. Even when you use encryption, ISPs can still capture data about whom you're talking to or what sites you're visiting. These data are sensitive, and consumers have a right to decide whether or not they can be shared or monetized. Unfortunately, the resolution of disapproval under consideration would strip consumers of that right and presumptively allow sharing and selling of that information without your permission. Mr. Speaker, the resolution before us today the Republicans have proposed is downright creepy, and it's going to allow potentially unprecedented abuse of personal or private information to be shared without your permission. This cannot stand. I urge my colleagues to oppose it, and I yield back the balance of my time.
Mr. Doyle reserves his time. Mr. Flores.
We reserve.
Gentleman reserves. Mr. Doyle.
Thank you, Mr. Speaker. At this time, I'd like to yield. First of all, Mr. Speaker, could I inquire how much time we have left?
Gentleman has 2 minutes. The gentleman from Texas has 2 minutes.
Thank you. Would like to yield 1 minute to the gentlewoman from Florida, Ms. Demings.
Gentlelady is recognized.
Thank you, Mr. Speaker. Mr. Speaker, please stop me if you've heard this one before and know how it ends. My colleagues on the other side are once again trying to sell the American people a broken alternative to something that is working pretty much as it was intended to. The FCC privacy rule just says that customers must opt in before Internet companies can sell their web browsing history, and that those companies must make reasonable efforts to protect customers' sensitive information. This is not unreasonable. This is not an unreasonable requirement. The Internet is our gateway to the world. Whether we connect through our mobile phone or a home computer, we pay companies for access. If those companies want to sell information about what we do on the Internet, they should have to get our permission first. It's the right thing to do, and I urge my colleagues on the other side to simply do the right thing. Thank you.
Mr. Doyle reserves his time. Mr. Flores.
We reserve.
Gentleman reserves. Mr. Doyle.
Thank you, Mr. Speaker. I ask unanimous consent to submit the remainder of my documents for the record.
Without objection.
Thank you, Mr. Speaker. I now yield 1 minute to the gentlewoman from California, my colleague from the class of '94, Ms. Lofgren.
Gentlelady is recognized.
Mr. Speaker, a yes vote exempts all broadband service providers from all rules on user privacy and all limitations on how they use your data. You know, they're in a unique position to see every place you go, every website you visit. They can do deep packet inspection and see what's in your emails. What protects your privacy? This rule that's about to be repealed. If you have problems with the privacy policies of your email provider or social network, you got competition to go to. But most Americans have just one or at most two choices for their broadband provider. And interestingly enough, all of those providers are supporting the repeal of this privacy rule. Why? They're going to make money selling your information. You know, the idea that we could have an FTC solution is an interesting one, but there's no way to do it. In the Ninth Circuit's 2016 ruling of AT&T versus FTC, they ruled that the FTC is barred from imposing data breach rules. So vote no, protect your constituents' privacy.
Mr. Doyle.
Mr. Speaker, our time has all expired.
Your time has
I thank the Speaker. I ask my colleagues to please vote against this horrible bill, and I yield back.
Gentleman yields back. Mr. Flores.
Thank you, Mr. Speaker. We've heard a lot of interesting claims today in the discussion about this fairly simple resolution to roll back overreaching regulations from the FCC that were passed late in the Obama administration's time. I would remind everybody, Mr. Speaker, that this CRA has nothing to do with the president's tax return. It has nothing to do with Russian hacking. And there have been some gross mischaracterizations of what this resolution does. Why do we need this resolution? 3 reasons, as Chairwoman Blackburn opened up at the beginning. First of all, the FCC swiped jurisdiction from the FTC. Secondly, 2 cops on the beat create confusion among consumers and among the ISP providers. And number 3, the FTC already has jurisdiction over this space. Let me say this. Let me close with this. This resolution only rescinds the FCC's rule, but it still provides the FCC the opportunity to provide more oversight, more in line with the Federal Trade Commission, which has successfully been regulating online privacy for nearly 2 decades. This bill does not lessen or impede the privacy and data security standards that we already have established. We are simply restoring a more stable regulatory playing field to ensure that consistent, uniform privacy standards are maintained to protect consumers and future innovation. Once Congress rejects these rules, the FCC can turn back to cooperating with the FTC to ensure both that consumer privacy across all aspects of the Internet is protected through vigorous enforcement and also that innovation is allowed to flourish. I urge all my colleagues to support this common sense resolution, and I reserve the balance of my time. All right, yield back.
Gentleman yields back his time. All time for debate has expired. Pursuant to the rule, the previous question is ordered on the joint resolution. The question is on 3rd reading of the joint resolution. Those in favor say aye. Those opposed, no. The ayes have it. 3rd reading.
Joint resolution providing for congressional disapproval under Chapter 8 of Title V United States Code of the rule submitted by the Federal Communications Commission relating to protecting the privacy of customers of broadband and other telecommunication services.
Question is on passage of the joint resolution. All those in favor say aye. Aye. Those opposed, no. The ayes have it.
Mr.
Gentleman
Speaker,
from Pennsylvania.
I ask for the yeas and nays, a recorded vote.
Yeas and nays are requested. Those in favor of a vote by the yeas and nays will rise. A sufficient number having risen, the yeas and nays are ordered. Pursuant to Clause 8 of Rule 20, further proceedings on this question will be postponed.
On this vote, the yeas are 215, the nays are 205. The joint resolution is passed. Without objection, the motion to reconsider is laid on the table.